All right, I'll see you all for jury trial tomorrow at 9:30.
You had said if we had any pre-trial motions to bring those up.
Yes.
All right, Judge. So I had filed a motion back in August, motion to prohibit the YouTube broadcast of all the legal proceedings.
And I don't have that motion. It's not in the court's file. We're going to have parties announced for the record for the state.
Anna Ochoa Nelson.
Defense.
Alex Scharf for Mr. Dillon.
All right, defense, your first motion.
Yes, Judge. The first motion is the motion to prohibit the YouTube broadcast of all legal proceedings in Mr. Diller's case. The basis for that is that he's got a constitutional right to a fair trial. And by broadcasting what happens during the trial sets up great room for error to happen. As you're aware, the court previously had a trial where one of the witnesses, the complainant, admitted to watching the YouTube testimony of at least another witness.
And you do realize that that complainant testified first, correct?
Yes, Judge.
Okay.
But just for example, that was a main witness and she admitted to watching YouTube. I'm concerned about witnesses watching YouTube. I'm concerned with potential jurors watching YouTube or asking friends or family to watch it for them. And so I'm just really concerned that Mr. Diller won't get a fair trial with this being broadcast all over the internet.
All right. Now, and would you want the media excused as well?
Usually the media doesn't video record.
Yes, they do.
Out of when the jury's out of the courtroom.
Welcome, folks. Today we have a truly compelling courtroom showdown. This is not your average legal drama. We're talking about a motion to prohibit the YouTube broadcast of an entire trial. But it's not just any trial. This involves serious allegations of injury to a child, the potential for deferred adjudication, and a defendant who seems to be skating on thin ice. The stakes are high as the defense raises concerns about the impact of public broadcasts on the fairness of the trial. With motions, recusal, requests, and witness scheduling conflicts on the table, we're in for a roller coaster of legal maneuvering. Will the court allow it all to unfold on YouTube, or will they decide to hit the brakes? Keep watching, because this one has plenty of twists, turns, and high drama to keep you on the edge of your seat.
Like, for instance, like if there's a motion in limine and we're arguing about prior criminal record or something, the court grants it. I don't think the news cares about that. But if a juror were to see that, or a witness or one of the witness's friends, then they could let that slip out when the court has already ruled on that issue.
So you're okay with the media coming in filming, is that correct?
I don't have an objection to that.
Okay.
I don't have it to that. It's just broadcasting everything that happens in the case.
All right.
The reasons that, and I will, in the motion on page 2, paragraph 5, I want to waive that paragraph.
Okay, let's break this down. The defense's concern here is pretty clear. They're worried that the public broadcast could taint the trial. They've already seen one case where a witness admitted to watching previous testimony online, and now they're playing defense, concerned about jurors or even the accused friends and family getting involved. The whole idea of a public trial is meant to ensure transparency, but does it risk turning the case into a circus? The defense argues that anything online can be distorted, misinterpreted, or even used to manipulate potential witnesses. It's a valid concern in the age of social media, but what do you think? Should we really worry about a fair trial being compromised by something as widespread as YouTube?
Because I do believe the court has changed the YouTube channel and does not allow chatting any further. And so I will waive that. I'm also concerned that there's an alleged victim who is a minor, and under the Texas Constitution, Article 1, Section 30A1, that person has a right to privacy, and that by broadcasting it, her name will be revealed. And also, whenever the jury is picked, their names are called out loud, and that's supposed to be done secretly.
All right. Is there anything else with regards to your motion, counsel?
Here's where things take a sharp turn. The motion to prohibit the broadcast is denied, and it's a moment of big stakes for the defense. The judge wants to move the trial along, but there's this looming issue about the wife of the defendant being a key witness and unavailable until the next day. It's an intriguing point of contention. Imagine being in the defendant's shoes. Your future hangs in the balance, and your primary witness can't be there on time. It's not just an inconvenience, it's a crucial part of the case that could make or break things. But the judge isn't showing any sympathy for the delays. In the courtroom, time is money, and every second counts. Does the defendant's team risk everything for a delay, or do they roll the dice and proceed without her?
Well, the main focus is the concern for Mr. Diller getting a fair trial based on only the evidence that is presented in court and not broadcast or archived videos of earlier proceedings that are watched by potential jurors and potential witnesses.
Okay.
And that's just too huge a risk.
All right. And this is your only pretrial motion?
No.
All right. So that motion is denied. What's your next motion?
I haven't filed it yet. It's ready to be filed. I can hand file it. Before I file it, I would respectfully ask the court to recuse
Okay.
on this case.
Sure. We'll have a hearing on that.
Okay.
And that will be heard by Judge Hall. Ms. Ferguson, if you could call Judge Hall to see if he can have that heard immediately. All right.
Okay. And then the motion was a motion to recuse
Okay.
on that.
Oh,
So
that's fine.
Oh, here's the courtroom drama at its finest. The defense attorney lays out the stakes, painting a picture of a man who's been through trauma, fear, and medical struggles. The defendant, Mr. Diller, is clearly shaken by the charges and the case's emotional toll. But there's a catch. He's got a history of being in a serious accident that's left him grappling with life-changing consequences. This is his big moment to address the court. But how does he do it? By acknowledging the pain caused in the incident, but also showing vulnerability. This adds a layer of human complexity to the case. While the judge is weighing the severity of his actions, you can feel the tension build. Will his medical history and personal struggles earn him sympathy, or will they fall on deaf ears?
Oh, counsel, you can file whatever motion you want to file.
Okay.
All right. And see if he can have that heard and let him know that this is scheduled for jury trial tomorrow. So perhaps if he can hear it in the morning, and that way we can move directly into jury trial. Is there any other motion?
not for today, Judge. Like, we'll probably have a motion in limine whenever.
All right. You may want that heard because technically you have not filed the motion to recuse yet.
Right. You are right.
So.
You are right. Well, I can file it electronically when I get back to the office, or I can hand file it.
Well, either you need to file it now. If you don't file it now, then we will hear other motions.
All right.
And now, it's sentencing time. The judge sentences Mr. Diller to 6 years of deferred adjudication. But it comes with a laundry list of conditions. No contact with the complainant, community service, restitution, and regular check-ins. But the real kicker here is the required medical disclosure. The court wants to make sure his prescribed medications are being taken as directed. This is one of those rare moments in court where the judge seems to be balancing compassion with accountability. Mr. Diller's medical history is being factored into the ruling, but the court isn't letting him off the hook. It's a nuanced decision, weighing his challenges against his responsibilities. The question is, will Mr. Diller rise to the occasion and prove that he can follow these terms, or will his probation end up in jeopardy?
Original 3 copies.
All right. And Ms. Ferguson, see if Judge Harl is available to hear that today. And we will be coming back here on the 17th for trial.
Oh, wait, today or tomorrow morning?
Let's see if we can hear it today or either early tomorrow morning.
Okay.
All right. Thank you.
Thank you, Judge.
You're welcome. All right.
Morning, Your Honor.
Morning. So we're having a jury brought up. We'll see where we are.
Oh, okay.
Yes.
Do you expect that to happen this afternoon or?
Today, we shall
Okay.
see. All right.
Oh, okay. I thought there was a murder case.
Oh, there is, but you never know. Sometimes
Sure.
things fall through.
No, you're right.
All right. Okay. Thank you.
Then what, you want us to hang around?
Yes. Hang around.
If we're gonna have a trial, I need to go back to my office and get my
Okay.
briefcase.
All right. We will definitely give you a chance to do that.
Okay.
All right. Thank you.
Thank you.
At this moment, we're starting to see the weight of Mr. Diller's situation sink in. The judge has just laid down a series of tough conditions, and the reality of the path ahead is staring him right in the face. Community service, anger management, and regular visits to probation, they all add up. But here's the catch. If he fails to meet these requirements, the consequences could be severe. It's clear that the judge wants to give him a chance at redemption, but it's not going to be easy. Will Mr. Diller be able to navigate these conditions and turn his life around? It's a pivotal moment in his ability to meet these requirements. We'll decide if he stays on the right path or winds up back in the courtroom facing a much harsher sentence.
All right. The party's on Philip Diller. All right. The court is in receipt for a motion for continuance from the defense. State, have you had a chance to review the motion for continuance? All right. Defense court will hear your motion.
Thank you, Your Honor. Well, I don't believe the state has an objection to it. And there's been some plea negotiations, but in reference to him being set for trial today is the last time we were set at the week before the March 25th, we could have gone to trial then. I know you were in trial. And as soon as we got the new court date for today.
And now we're in the final stretch with the judge driving home the importance of communication. It's not just about following the rules, it's about making sure probation knows when something's off, whether it's medical issues, employment, challenges, or anything else that might impact his ability to comply. The clock is ticking for Mr. Diller, and the pressure is on to prove he can meet all these terms. It's not just about doing the time, it's about making the most of this second chance. The judge is giving him the tools, but it's up to him to use them. The big question, will he take this seriously and turn things around, or will he fall short and face even worse consequences?
Everyone in the box, please whisper. Yes, you may continue.
And so when I let Mr. Diller know, his wife chimed in immediately, I cannot be there the April 8th through the 10th. She'll be back from a conference that's mandatory for her employer, which is Southwest Research. She'll be back tomorrow, probably late in the afternoon. What's that? 8 p.m. tomorrow.
Okay.
But she's a crucial defense witness. In the motion, I outlined what I expect her testimony to be. I have interviewed her. And I have also attached an affidavit that details what her expected testimony is. She is a crucial witness for the defense.
All right. So here's my thing. You're saying she'll be back on tomorrow by 9 p.m.?
Yes, that's
all right.
expected.
So we would do jury selection. If your case is going, we'd do jury selection today. And I don't think the state is going to finish with.
So what do we have here? Mr. Diller gets a second chance, but the pressure's on. 6 years of deferred adjudication, strict probation conditions, and a final chance to prove he can change. The judge has given him the tools, but the real work starts now. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more gripping courtroom breakdowns. Who knows what twist is coming next? Stay tuned.
Their case, or they may be finished with their case in one day on Wednesday, but she probably will not need to be here till Thursday.
Then, then that would obviate.
All right, so there's no need for the motion for continuance?
Well, if the court is going to work around the schedule.
I mean, if you're telling me that she will be back on April 9th.
Be back the 10th.
The 10th. If she'll be back on the 10th by 9 p.m., If her testimony is needed, it will be needed at the earliest on the 11th. So there's no need for a motion for continuance? Is that correct?
Well, if I mean, I'm not, I'm just saying she can't, if she wasn't here yesterday, she can't be here today, and she won't be here till tomorrow night.
Well, it appears that her testimony is not going to be needed if you wish to call her.